Very good. Thank you for coming today.
Mr. Chairman, committee members, my name is Hal Carlson. My wife and I own a Powell's Sweet Shop franchise in Chico, and we urge your support of this bill. Thank you.
Thank you very much.
Balwinder Singh, 7-Eleven franchisee from Thousand Oaks, California. I would like to get your support, please.
Great. Thank you.
My name is Bruce Napel. I'm a franchise attorney. I've been specializing in representing franchisees since 1998, and I'm a certified specialist by the State Bar. And I'm actually available if you have any technical questions, and I do support this bill as well.
Thank you.
So Jasveer Rana from Sacramento Shell Owners. I would like to support this bill.
Great. Thank you very much. Good afternoon. Welcome.
Good afternoon. Jasprit Dillon, 7-Eleven franchisee from Reseda, California. I strongly support the bill. Thank you.
Thank you for coming today.
Good afternoon. John Gordon, Pacific Management Consulting Group in San Diego, with a 40-year background in restaurants and working for both franchisees and franchisors. This bill is absolutely required. Please support it.
Very good. Thank you. Appreciate that comment.
Paul Diol. I'm a Subway franchisee for 23 years in Butte County, and I would really like to see your support for this bill.
Very good. Thank you.
Madhusudan Sandhu. I'm a franchisee for Chevron and AMPM Arco and would like you to support this bill, please. Thank you.
Thank you for being here.
Good afternoon, Chair Tia Orr, on behalf of the Service Employees International Union, on behalf of the workers who are employed by these many franchisees, we are in strong support.
Very good. Thank you.
Mr. Chair, members, Sarah Flocks, California Labor Federation, also in support of the bill. Thank you.
Thank you.
Hi, Raju Wal with the Subway and 7-Eleven franchise. Need your help.
Thank you.
It's Jesse Tawana, and on the franchise MPM in Oxnard, we need strong support. Thank you so much.
Thank you for coming today.
Baljinder Sidhu from Torrance, California. I request a strong support of this bill.
Very good. Thank you.
Good afternoon, Baldev Dhiman, Orange County, franchisee 7-Eleven and Subway. Please support this bill. Thank you.
Thank you for coming. Good afternoon, sir.
Afternoon. Max Sandhu from Palm Spring. I'm in a franchise, motor franchise business. I would like to get your support for that.
Thank you. Others in support? See no one. Witnesses in opposition? Please come forward. Gentlemen, I think if you could leave a little room for them, I would appreciate a couple. Thank you. You can. Chris, do you want her? She can stay. Whatever you want.
Mr. Will present first?
Members of the committee, Randy Pollock on behalf of a broad array of trade associations and companies, and we're in an opposition unless amended position. I represent personally the International Franchise Association that represents 1,300 franchisors and 13,000 franchisees. And conceptually, we're in a lot of agreement with this bill. However, we want to make sure that in passing a bill, we want to make sure that everything is set, because this bill is going to be operational for the next 10, 20, 30, or 40 years. So in coming back with amendments, we know it's a very tedious process, and we're very thankful to the assemblymen, both assemblymen here today and their staff, and also the committee consultants to make sure that we get things right. I'd like to raise a couple points, and Mr. McKaylee will raise a couple points, is how we believe that we need to fix this bill to make it better and stronger for everybody involved. I first wanted to address the issue dealing with terminations and non-renewals and the monetization part. I think we all agree that there should be some sort of compensation paid to someone whose franchise is not renewed. And in the language, we're supportive of that. The issue we have with that language is to also discuss that we are also responsible for compensating people who are lawfully terminated. Now, the issue there is what happens if you have someone who abandons a franchise, is convicted of a crime, files for bankruptcy. The franchisor does not take that over. So that premises is still there. The equipment is still owned by the franchisee, who has the right to dispose of it in any manner available to him. You know, he can sell it on eBay, he can sell it to another vendor. But in this situation, we don't believe that the franchisor should be obligated to pay for the wrongful actions of someone else. And we believe that's a very easy fix. We don't think that that would be too complicated. And I think in some of the discussions that we've had with the proponents, they've understood that position. Why should we have to compensate someone for something that we aren't even taking over? Additionally, I just want to raise another issue dealing with the reasonable standards part. And we appreciate, again, the Assemblyman for taking amendments that in a transfer, that standards have to be consistently applied to other franchisees. However, they left in the word reasonable standards have to be consistently applied to other franchisees. Our concern there is now you're putting into question the standards of the franchise. What is reasonable? And so is there an opportunity that every standard that's in your agreement, is it subject to a reasonable interpretation? What is more important here is that there was concern among the franchisees that when a transfer occurs, they want to make sure that it is equally among all the franchisees, that all of them have an equal opportunity of obtaining that franchise. But we believe that is accomplished with the language in the recent amendments. However, by listing the word reasonable, we believe that caused them to doubt as to raising each standard, is that reasonable or not, which will lead to more litigation. The last issue that I'll quickly raise is about the reinstatement part. The reinstatement part was amended where it says that reinstatement is only available if it's practical or not impossible. The question that we have there is if a franchisee believes that the franchise is being taken away from them unlawfully, they have the opportunity of going for an injunctive relief pending any transfer until the outcome of that adjudication. We believe that is the proper process. And then they still own the property of the business until there's an adjudication. This other way it's set up, we're concerned about a year later, 2 years later, a franchisee will sue and say, I was unlawfully terminated or unlawfully not renewed. If a court determines that is correct, they're going to get the fair market value of the business. There's no argument about that. But now we're concerned is there a possibility that now a franchise has to be reinstated? And how would that be conducted? So we're very concerned about that provision. So like I said at the beginning, I think we're very close. I think we're moving in the right direction. And I think a lot of the language that we're talking about, we believe is more technical in nature. Thank you.
Thank you. Mr. McKaylee.
Excuse me, Mr. Chair, members, Chris McKaylee on behalf of the Civil Justice Association of California. As you know, our charter is concerned about potential litigation, and I would raise 3 quick issues in our opposed unless amended position, and we too appreciate the very extensive analysis prepared by your consultants. The first is, as is noted on page 11 of your analysis, we have concern over changing the definition of good cause and changing that standard to be substantial compliance. Your analysis notes that 5 states utilize that standard along with a 60-day right to cure, and we don't think that California should be in the minority of those states, and we would prefer to keep the current good cause language in the franchise law. The second concern is that which reflects on page 12 of your analysis on the right to cure. I would note that under the Private Attorney General Act, businesses in certain instances have a 33-day right to cure. We think that appreciate the comment that was noted in your analysis that because of the current language up to the 30 days, I think is the way the franchise law reads, that some franchisors have substantially reduced that time period to track similar language out of PAGA. They state that the cure should be done within 33 calendar days of the notice. So we would prefer something comparable, not a doubling, and perhaps under the proposed committee amendments, more than a doubling and a half to 75 days, which we think is excessive. I would also raise the question on page 4 of the bill, line 20, in subdivision G. How is the term repeatedly viewed? There isn't a definition. This is one of the exceptions in the right to cure. I'm not sure if that is 2 violations or 3 or 4 or 5, but how is repeatedly defined? And lastly, the key issue that CJAC raised in its letter is the effective date. And I understand that the author has agreed to some language that is mentioned on the last page of your analysis that'll be prospective in nature. How exactly is that being defined? Is it for franchise agreements entered into on or after 1/1/2016, which is sort of the standard effective date language we would utilize, but I would certainly appreciate some clarification, as that is one of the fundamental issues that CJAC has raised, in that there are a substantial number of changes to the law proposed in this bill. I think your analysis notes a good 20-plus changes in the law, and again, we think that those should be done prospectively in nature. Thank you.
Thank you, Mr. McKaylee. Others in opposition to the bill, please come forward, and if it's new information, please state it. If not, then just your name and who you represent.
Good afternoon, Mr. Chair. John Moffett on behalf of Dunkin' Brands, which is the franchisor for Dunkin' Donuts and Baskin Robbins. I think from our perspective, just a couple minor things that we'd like to add to the previous testimony. I think the examples that have potentially been held out as systemic, broad, widespread abuses of the system, I'm not sure that's what we're talking about here. I think what we're talking about in this bill are specific examples. Granted, there are situations where franchisors don't act nicely, and that's unfortunate. But I don't think we're talking about what happens day in and day out. Yet we have a bill that changes the law for thousands upon thousands upon thousands of franchise contracts here in the state of California. If the bill passes, and I want to clarify this for my client because it's been stated in hearings before, if this bill passes as is it the end of the world? No. Will Dunkin' Donuts not do business here? No. Are we going to close down stores? No. Will the bill make it more difficult to do business here? Yes. But do we want to continue doing business with California entrepreneurs and expand here in California? Absolutely. We absolutely do. And as I said, with that, we still believe that there are some illogical inconsistencies in the bill. Some of them were already noted. Lawful requirements. The example that the committee was given was window washing and terminations for window washing. Well, that's one thing, but, franchise agreements also cover things like minimum liability insurance limits. They cover things like workers' compensation. They cover things like health and safety. They cover things like point of sale systems dealing with encryption and customer protection. You're bundling all those things together in this bill and saying, well, maybe we don't need to follow all these. Well, pick which ones. There's probably some bifurcation that can happen here, but it requires a little bit more work on the bill to get there. Secondly, reimbursement. A franchisee who has acted so egregiously that they can be terminated under the law that's not being changed by the bill could still seek reimbursement for inventory and things like that. That seems inconsistent. The bill, what if two parties agree to not renew? Reimbursement still is in effect. What if they just say, I'm ready to retire, I'm ready to be done? Reimbursement is still there. And last, the bill talks about depreciation in that scenario. What kind of depreciation? Straight line depreciation? Is it depreciation claimed by the franchisee on their tax records? Would we have to go to tax records to figure out what that depreciation is? I don't know. And then last, as was mentioned before, one of the remedies in the bill after including an action for damages and an action for an injunction is still forced reinstatement of a franchise. And we don't think the law should force two parties who don't want to do business together to do business together. With that, we reiterate our desire to continue working on the bill. We agree with the statements by IFA that we're not as far apart as we might think.
Thank you, Mr. Moffett. I have to leave and present two bills. I just wanted, because the bill may be, the issue may be resolved before I get back, I just want to thank Assemblymember Holden, Assemblymember Wilk, and the other co-authors for doing a tremendous job of really working. I think you're getting to that collaborative effort that's important, and I think there's still, and as I saw you taking notes of issues that may come, that are coming up, that you may be more rebuttal or more, I thought it was more refinement maybe of the bill, that you may look for some amendments to keep that collaborative spirit going. But I think this is a good bill, and I'm glad you're doing it. So I'll turn this over to the Vice Chair.
Thank you. Thank you, Madam Chair and members. Doug Subers on behalf of the Western States Petroleum Association. I'd like to associate myself with the previous comments, but raise one distinct issue, if that's okay. Section 10 of the analysis raises an important issue from our perspective. The bill right now limits good cause to substantial compliance with the franchise agreement. In the gasoline station convenience store context, there is a federal law, the Petroleum Marketing Practices Act, that governs the fuel portion of the franchise. However, the state law will govern the convenience store portion. We think the limiting of this good cause as it's proposed in the bill would narrow the one side significantly more than what is in the PMPA, and there would be inconsistencies on site. And we think we want to continue to work with Assemblymember Holden and the committee. We think this may be an issue that could be addressed and clarified, but we'd like to raise that as a concern that we think we'd like to work through as the bill keeps going. Thank you.
Afternoon, Chairwoman and members. Teresa Cook on behalf of BP America, the franchisor of 700 AMPM stations in California, respectfully opposed.
Thank you, Madam Chair and members. Kate Bell on behalf of the California Retailers Association, some of whose members include Jack in the Box. We have an opposed unless amended position. We do thank the author for having sat down and worked with us and accepting the committee amendments that are related to the analysis. We have a couple of minor tweaks to work out, hopefully, in the next few weeks. And with that, we still remain opposed unless amended. Thank you.
Good afternoon. I represent Mr. Zheng Feixiang because he cannot speak English. Sorry about that. He owned the Golden Corral, a buffet restaurant in the San Bernardino County. He opposed this bill.
Did everyone hear that? He is speaking in opposition, correct?
Yeah. He opposed this bill.
He's opposed, okay. Thank you. Next.
Good afternoon. My name is Mike Sendro. I'm a Jan Pro franchisee, and I oppose this bill. Thank you.
Good afternoon. My name is Ralph Ascar. I've been in the franchising business for about 30 years. I've been on both sides of the fence. I am currently a franchisee of two concepts, the UPS Store franchise in San Diego County, as well as Instant Imprints in San Diego County. I oppose this bill for the reason that I've read my franchise agreement and I've abided by the provisions of the franchise agreement, and no one has bothered me for anything through the course of the time that I've owned my franchise. Thank you.
Madam Chair, members, Bo Biller on behalf of Bruce Double D McRae and UPS, and I didn't choreograph that, but good timing. So UPS remains opposed unless amended.
Thank you. Any others in opposition? There are none, and I will go to the committee. Any comments or questions?
Yeah.
Senator Berryhill?
Madam Chair, this is a classic bill of, it sounds like that it's close. It's just not, doesn't seem to me to be quite cooked enough. I mean, can we get there in this thing, or what's your opinion here? Yeah.
Go ahead.
Okay. Mr. Berryhill, I think we're very close to agreement. I think that we can work out the remaining concepts. I think it's just going to take a little bit of time to getting the parties together.
Yeah, there's of course plenty of concern on our part to see how many people are still opposed to this bill. That being said, I think I'm going to lay off this bill today and see what happens. I appreciate the fact that you're working with everybody, Assembly member, and look forward, once you get this thing fixed, to voting for this on the Senate floor when it gets over there.
Good.
Thank you.
Any other questions? Senator Wieckowski?
I got a question. I'm reading on page 10 of the report this franchisegrade.com survey that they talk about, and they're saying only 22% of the franchisees people believe that they make a decent living, and 79% of them say that they earn less than $50,000 from their business. So I guess my question is that one of the concerns was that the opposition, the effective date is going to be January 1. And I think if I understand it, you're saying it's, even if you have a substantial amendment, because you may have an existing, you've got 78% of these unhappy people making less than 50 grand. So if the agreement is amended, then they would have effect, they would have the benefit of the bill as presented. Am I correct in that?
That's right. That's right, Senator. What we tried to do is we were increasing the time frame to 60 days. We had an opportunity to meet with the chair as well as the opposition. He was very thoughtful in trying to bring everyone together. We appreciated that effort. A lot of what I'm sure you heard today, he had an opportunity to hear as well. And one of the amendments that was proposed was just rounding it up to a cap because it said up to or not to exceed. And so there was some concern about whether or not the number could move. And so to have a firm cap seemed to be an area that he thought we needed to be responsive to, and that's how we ended up with that reflected in the bill.
I guess the questions for some of the franchisees who aren't here is that we're looking at the contract and the day of the contract or amended and effective date. How about the actual dispute, the incident? Because it seems to me that there'll be some franchisees who entered the contract 5 years ago, right? And then come February, they're washing their windows and they get cited by the franchisor of some horrible their non-compliance. How would this legislation affect those folks? Would they have 60 days to correct it, I guess? Stop washing them?
The 60 day, well, it's actually based on
75.
75, yes.
So those other provisions of the bill are covered here, or everybody's covered.
Yeah, moving forward, it's all perspective. This is not retroactive anyway.
Okay. Any additional questions or comments from members? Briefly.
Sorry for my lunch. I want to thank you for bringing this bill. I know this subject. I have a little experience with it. And I think it's really important that we recognize the relationship here and the importance of what you're trying to do to balance this out. So I haven't heard the discussion, but I think I know most of it. And I'd be happy to move the bill.
There's a motion. Senator Block?
Yeah, thank you. I was going to say this is a better bill than last year, no offense. No, I voted for last year's bill. This year's bill seems more, has been subject to more negotiation and I think more interplay between the sides, which is appropriate. I hesitate to even say sides because in most of these agreements, it's a partnership. There are bad actors in every industry, and there are bad actors who are franchisors. There are many good actors who are franchisors. I've got a corporate office of Jack in the Box in my district, and I think they do a fine job in what they do. There may be some outliers with any company, but on the whole, there are a lot of franchisors who, frankly, can operate well under the current law. But there are some franchisors who don't, and that to me is clear. And I think part of our responsibility as a legislature is to protect those who are most vulnerable. Now, knowing that the franchisees, have had the advice of counsel when they enter into their franchise agreements, they've gone into this with open eyes. I don't have total sympathy, but I've heard enough stories from franchisees where they are clearly the David battling a Goliath, who need help from the legislature, the protection. That's part of what we do. I'm glad to hear this is prospective. I think it should be. That was an important amendment to take. And on the whole, although I'm, conflicted on this, I will support this bill.
Thank you. Any other comments? Committee, we do have a motion. Assemblymember Holden, I'd just like to say to actually appreciate the work that you've done in meeting with all the groups. There's a huge group on either side of the issue. I'm concerned about the potential for litigation, in particular with some of the technical amendments the opposition have asked for, because California is the most litigious state, and we can always find a way with I think some of the vague references and the term substantial compliance is a big issue. So I will be voting no today, but I am very pleased that you're going to continue to work, I hope, on some of the issues. And so when it's going to judiciary from here, and then some of that can even get more refined, because we know you've done, and your co-author, some heavy lifting on this to continue to meet and try to navigate through some of the issues. So we thank you for that. And you may close.
Well, thank you. And I would also like to recognize Senator for her efforts last year, because it really was the foundation for 525. And what Senator Jackson was trying to accomplish, you heard the testimony today. There are franchisees, small business owners, who are falling through the cracks, who are being put in positions where their livelihood is being snatched out from under them for whatever the reason. And that's not to paint with a broad brush and say that every franchisor is a bad operator. But we do know and have seen, and there has been a federal case to call upon this issue. And so we're not manufacturing anything to create fear. We are responding to what's happening in the world. And we also can say that we are pulling from states that have used legal language that has been clearer. We are being responsive. The senator's bill made it all the way to the governor's desk last year. The governor was very clear on the things that he saw that needed to be fixed. And the process that we went through with 525 was to take the senator's bill and to respond to the governor's veto message and to be as inclusive in the process of engagement as we could to address those concerns. We have continuously stayed connected with the governor's office to make sure that they understood the types of changes that we were making to be responsive. And we've even gone beyond many of the concerns he had. And so I think that a lot of times through this process, we can, your bills can can die of 1,000 nicks. It doesn't seem like much here or there, but by the time you go to stand up, you fall apart because you've been cut to shreds and didn't know it. So then you don't have anything really that's protecting the very people that it was designed to do. So I think we've made important movement here. I think we're putting forth a bill that is really a strong bill for small business owners in the state of California that happen to operate in a unique relationship called a franchise relationship. I appreciate the committee's consideration of the bill, and I respectfully ask for your vote.
Madam Clerk, will you call the roll?
Motion is due pass as amended to Judish. Hill? Bates?
No.
Bates, no. Berryhill? Block?
Aye.
Block, aye. Galgiani? Hernandez?
Aye.
Hernandez, aye. Jackson?
Aye.
Jackson, aye. Mendoza? Wachowski?
Aye.
Wachowski, aye.
It's on call. It's on call. So, and then when it's passed, it'll go to judiciary. And you did accept the amendments that were, you did. Thank you. Thank you. Very good presentation. Next item is, we did. Item number 6, that's AB 624, Assemblymember Wilk. You can just move over one seat.